सुनील सुनील अभी जरा 1 मिनट रुको। एक मिनट राहुल राहुल का इधर राहुल का राहुल Good afternoon, everyone. Any president that takes over the term, one of the most anticipated events, which essentially heralds the term, is the study circle. Now, our study circle meeting is, I would say, that one of our most primary responsibilities. And with that, we also have always had a tradition that we have the president of the MSTT and all the other members. President is the chief guest, and the other members are the guest of honors. So I welcome each one of them, and I would request Rahul, please escort them. Escort the president. Yeah, sorry. Before that, I request each one of you, all the tribunal members, sorry, to please come for the lighting of the lamp, and after that we can begin the session. Yes. एक फोटो लीजिए सर। हाँ जल्दी आ And the secretaries will be escorting the guest. Oh. Hello, Mr. Secretaries.
Good afternoon, everyone. I now request the secretaries to please escort all the dignitaries to the dais. The chief guest, the speaker, and other dignitaries to the dais. Very good afternoon to everyone. Respected chief guest, President of Maharashtra Sales Tax Tribunal, Shri Tarareji, judicial and tribunal members, President, Advocate Parth Badeka, office bearers of GSTPAM, past presidents, seniors, members, and my colleagues. As a convener of Study Circle LNR Committee, it is both an honor and privilege to welcome you all to this inaugural Study Circle meeting. As we march into the 75th year of our organization, we celebrate not just a milestone, but a legacy of excellence, leadership, and unwavering commitment to our professional community. This 75th year is a tribute to the pioneers and the founders who carried the torch and also to the new Gen Z, which is poised to take us into the future. This is a time to reflect on our achievements, renew our mission, and reimagine towards what lies ahead. I once again extend a heartfelt welcome to all the distinguished dignitaries and each and every member present physically as well as online. Your presence here reaffirms the strength and unity of our professional community. As we dive into today's topics, let us all keep our minds open, questions flowing, and our conversations engaging. The goal of this study circle is not just to absorb information, but to grow together both professionally and personally. So let us all make this session ahead a meaningful one. I now request Honorary Joint Secretary Shri Sunil Joshi to introduce our chief guest, Honorable Shri P.S. Tarareji. Good afternoon. It is indeed a pleasure and privilege to introduce Shri Pramod Shravan Tarare sir. He was born in the place Chandrapur in the year 1962. His qualification BCom LLB. He has started his practice in the district and session court of Gadchiroli and Chandrapur in civil, criminal court and revenue court. He has been selected as district and additional session judge in the year 2008. His work experience includes district and additional session judge at Jalna, Yavatmal, Aurangabad, Vaijapur and Nagpur. He has worked as additional principal judge in Bombay Civil Court and Session Court and special judge in CBI Court, Mumbai. He has worked as principal and district session judge at Nandurbar. He has worked as a charity commissioner Maharashtra State, Mumbai. He retired in the year 2022. Then he joined as a member of Maharashtra Sales Tax Tribunal in the year 2022. He has then joined as a president of Maharashtra Sales Tax Tribunal in the year 2023. With this brief introduction, I present before you today's chief guest, Shri Pramod Tarare sir. Now I request our president sir to honor our chief guest with a memento. Thank you, sir. Now I request.
Now, may I request President Parth Badeka to also honor our members from tribunal who have given their time today for this session. May I request Parth Badeka sir to please honor Shri M.S. Pathan, judicial member. may I request now President Parth Badeka to please honor Shri Budre sir, our judicial member, with a flower bouquet. May I now request Parth Badeka sir to please honor our technical member Shri T.R. Ramnani sir with the flower bouquet. And also to Dr. Alvarez sir, technical member. Thank you to all the members for giving their time today and coming to this session. Thank you so much.
Now I request Chairman of Eleventh Committee, past President Pranav Kapadia sir, to say a few words about the study circle.
Good afternoon, everybody. Respected President of Maharashtra Sales Tax Tribunal and the chief guest today, Shri P.S. Tarare sir. Respected judicial members, Shri M.S. Pathanji and Shri Gudreji. Respected technical members of the Tribunal Bar Association, Shri Ramnani ji and Dr. Alvarez ji. President of GSTPAM, Parth Badeka. All the office bearers, Rahul Thakur, Jatin Chheda, Vinod Maske, Sunil Joshi ji, past presidents present over here, and all my dear friends. A very good afternoon to all of you. Well, it is said that well begun is half done. Our president, Advocate Parth Badeka, has really taken very good initiatives at the beginning of the tenure and planned various activities of our association in this glorious 75th year of our association. And amidst that, we have this inaugural study circle meeting. Like Parth already mentioned that we have the privilege of having this inaugural study circle meeting and the lighting of the lamp by the president of the Maharashtra Sales Tax Tribunal Bar. And we are indeed very privileged to have the president of that association with us today, and the esteemed judicial and technical members are also there with us. So thank you very much, all the members, for your gracious presence in this inaugural study circle meeting. Well, friends, as regards the study circle is concerned, yes, since all these years, our study circle meetings have been the backbone of learning for all our members. And even in this year, we have planned the various study circle meetings, and the topics are planned as per whatever recent developments are happening in the law and what is of very much relevance and importance to all our members. With that in mind, today we have a topic on fungibility of input tax credit, especially in case of amalgamation, merger, demergers of companies. And the second topic is refund of input tax credit lying in the electronic credit ledger in case of closure of business. What are the nitty-gritties of claiming that? We have two very important judicial decisions on both these topics. And to deal with these topics, we have our very own member, Advocate Ratan Samal ji, who will be guiding us on the nitty-gritties of this topic and the various aspects involved in claiming this credit, and what are the views of the department as well as the judicial members on this. A very, very important topic for all of us. I am indeed very grateful to all the members who have joined here physically as well as online. Also, there are various members who have joined it. So thank you very much for joining, everyone. And let's hope this year, the 75th year, we are able to provide
more education and more clarity on the GST law to all our members. With this, I now welcome upon the President, Shri Tarareji, to give his opening remarks for this inaugural study circle and bless us all. Thank you very much, everybody. Thank you.
Respected dignitaries present on dais and my friends, I am truly honored and delighted to extend my heartfelt appreciation to the Goods and Service Tax Practitioners Association of Maharashtra for organizing this study circle meeting on the subject legal analysis of recent judgments in GST. This initiative is a testament to your unwavering commitment to fostering knowledge and understanding in the field of law. By doing so, you not only break the stereotypes surrounding of tax law, but also equip the budding legal minds with practical real-life knowledge that will serve as invaluable foundation for their future career. The experience gained will contribute to the development of competent law practitioners. I am confident that this endeavor will sow the seeds for a brighter, more dynamic future in the realm of tax law. I wholeheartedly support your efforts. Once again, I express my deepest gratitude and admiration for your commitment to the excellence in the legal field. With these few words, I stop here. Thank you.
I now request Secretary Rahul Thakur to give vote of thanks for this inaugural session.
Respected President Sir Shri P.S. Tarare, respected members of the tribunal, and respected all the my seniors and office bearers on the dais, Shri Pranobai, the chairman of the LNR committee, the past presidents sitting in the audience, and all my dear friends and colleagues. So before I start my vote of thanks for this inaugural session, I would like to first make some couple of announcements. One is we have already announced the intensive study circle sessions for the year 25-26. The first session is set to begin on 23rd of August. Topic is RCM on government services. Group leader is our own LNR convener, Mr. Umang Talati, and monitor is Shri Deepak Thakkar. And we request everybody to kindly enroll for the program. It has always been a great enriching experience when we enroll for these intensive study circle meetings, heated discussions and debates, and in-depth analysis of the provisions of GST. And therefore, I request everybody to join in large numbers. And second announcement would be definitely the AI workshop, which we are announced on 21st and 22nd of August. It is a unique workshop. There are a lot of associations doing AI workshop, but as far as GSTPAM is concerned, the only association which is going to give you hands-on practice, and everybody is in fact expected with their laptop in this particular hall to have the first-hand experience of how to use AI. And there are 6 speakers on AI. One of them is, of course, Ratan Samal, our today's speaker's son. And it is going to be a huge enriching experience again for all the members to use the AI in today's date. Once upon a time, seniors like my father, he has done many classes for learning how to use computer, but even today he is not able to do it. But we want to ensure that all our seniors and all our practitioners make sure that they use AI in their daily life. It is going to help them in their routine work, at least for some letter drafting, some research work and all those things. So this program is built around that ideology and that concept in mind. And we are in fact keeping it a hybrid program with not less than 40 people sitting in this hall. We have already got around 44-45 participation for this program, and we are expecting many more by 21st of August. And that is what the two program announcements are. And now I come back to the vote of thanks. As told by my senior President Parth Badeka as well as Shri Pranav Kapadia, this inaugural study circle is by tradition. We always have our chief guest, Shri, the President of the Maharashtra Sales Tax Tribunal Tribunal as our chief guest, and all the members. And soon we are going to have GST Tribunal also. And we, as a GST Bar Association or GST Association, we are going to have two tribunals. One is VAT Tribunal, one is GST Tribunal. If it is merged together, no problem, sir. But if it is going to be two different associations, we will still continue with our tradition. That is what our commitment would be, that it has to be a tradition which cannot be broken, and it is a good tradition which nobody wants to change. Thank you for giving time for this association, sir, for today's session. It is an enriching session. Please attend that in entirety. And I also thank all our audience members present over here, our past presidents who have on one call. Dinesh Bhai has come today for this meeting. Thank you so much. And all our members who have attended it online, thank you so much for coming. And please enjoy the entire session. Thank you.
वीडियो को डालो, वो वीडियो भी चालू कर दो।
गड़बड़ हो जाएगा।
ये तुम शेयर कर दिया? मेरे को बोल दो, मैं करूँ, अभी नहीं। Voice is not clear. Voice देखो जरा. Is the voice clear now? Pranav bhai, just check. नहीं नहीं, not दूसरा Pranav. Pranav check. Okay. Okay, friends. This is not as per protocol that I am not supposed to speak. क्या क्या हो गया इसको? This is not as per protocol that I am not supposed to speak because now we are eager to listen to Ratan Samal sir. But there was some announcement that I had to make. And after a great deal of research and a lot of haggling with several hotels, we are proud to announce our RRC from 29th January to 1st February at Ananta Pushkar. It is an untouched destination. It is an untouched destination till now, and most importantly, the topics that have been suggested that we are thinking are going to be some which are as per our regular trend that we do, and some very interesting things which we have thought of. And within a week, all the topics, the paper writers may take time, paper writers and chairman may take time, but all the topics within a week, hopefully by the end of this week, we will be coming out with a very detailed circular, and the detailed circular will have all kinds of travel details, because I understand Pushkar is a very it's a destination which has very, I mean, has some challenges in connectivity, but we have figured out several ways, and we have found, I mean, we are going to give you pick up, drop, everything. So I request everyone to please save the date, and very soon the detailed circular will also follow. Please enroll everyone. We want maximum participation. This is our 50th RRC. So with that, with this announcement, now we go back to video. Kidhar hai? Sure. We'll share the video later. The video is not working properly on this screen right now. We'll share the video later, but several more details very soon will be announced. So thank you. Now we come back to our regular proceedings.
Friends, the time has finally come. Now I request our treasurer, CA Jatin Chheda, to come up and introduce our speaker for the day. I request Sejal madam to please escort him to the stage first. नहीं, बंद करो. I now request our honorary treasurer, CA Jatin Chheda, to come up here and introduce our speaker for the day, Advocate Ratan Samal.
Thank you, Ajay. Indeed, it's a great privilege for me to introduce our own member, Sri Advocate Ratan Samal sir. He is practicing in a direct and indirect taxes law before the various authorities like a High Court and a Tribunal Bar. He is practicing across from more than 3 decades. I think so, sir. Sir, right? 3 decades, more than 3 decades. 35 years. 3.5 decades. And he is regularly delivering the lectures and training session to the tribunal members, chartered accountants, advocates, and the GST practitioners. He regularly appears before the several authorities and as a special counsel for the state of Maharashtra of the value red tax and Bombay sale tax matters in the pre-GST era. Mr. Samal has acted as an amicus crucial for the Maharashtra Sale Tax Tribunal in the various cases, assisting in benches in the complex issues of a tax laws. Mr. Samal has previously served as the president of the Sale Tax Tribunal Bar Association. His achievement not only includes successful winning in the several complex issues in the direct and indirect taxes, but also in appearing in public interest litigation petition for the improving emolument of the judges, securing education for the specially disabled person, and appearing in writ petitions for improving administrative setup of the tax tribunals. During his earlier years of a practice, he has also worked as a visiting professor at the University of Mumbai College, such as KC Law College and New Law College, Rupare. With this short brief introduction, I welcome Sri Advocate Ratan Samal. And now I request our President, Parth Badega, to offer a memento as a Chairman, Sri Pranav Kapadia, as a mark of a love and affection from the our association. Now I request Ajay to take a further proceedings.
Thank you, Jatin. I now request the speaker for the day, Advocate Ratan Samal, to take these proceedings forward.
Respected President of the Association, I will call it Arjun. I will call it, President of Association as Arjun. Why? The reason being, Parth is nothing but Arjun under the Mahavar. And our chairman, Pranav Bhai Kapade, who is Krishna, and other respected office bearers of this association and all participants, my senior friends, those who are over here as well as on the online. It's a great privilege and a pleasure to be here on the first study circle meeting to discuss about the two judgments, very important judgments. So to digest those two, these two judgments, it took long time to me also. And certainly yesterday we prepared a digest of that and we have circulated it. And those who are, I think, outstation members, they also got this digest. Now, not to waste much time, let us go to the topic, in fact. There are two decisions under the GST law on the input tax credit issue. So first of all, I am taking this SICPA India Private Limited and another versus Union of India. This is the judgments of Sikkim at Gangtok bench, High Court. Now, this is a very peculiar and important decision which are selected by our association. And how it is to be looked into this judgment, and in our day-to-day practice, how we are going to utilize it, let us discuss on this judgment. The brief facts which I have already given in the note, and for convenience, I'm pointing out that this particular company, petitioner, is engaged in the manufacturing of security inks, had GST regime in Sikkim, GST registration in Sikkim. And in January 2009, they decided to discontinue its operations in the state and later sold its machinery and manufacturing facilities. Now, at the time of reversal of the input tax credit, as per the GST law, he has reversed it and the company applied for refund. for the balance unutilized portions of the input tax credit to the extent of some 4.37 crores. As per section 49(6), they have claimed, this company has claimed that we are entitled because we have closed the business and whatever the unutilized input tax credit as per section 49(6), we are entitled. Hence, they have made an application as per the provisions of section 54. The additional commissioner has rejected it. Then the matter came up before Honorable High Court. They have rejected on the ground that the revenue has rejected on the ground that there are some stipulations and conditions prescribed under 54, section 54, subsection 3. And beyond that, those stipulations, the revenue cannot grant this refund. Then the matter came up before Honorable High Court. High Court has analyzed section 49(6). For your convenience, because this is most important aspects, 49(6). 49(6) is a substantive provision. Kindly note it. It is a substantive provision which directs certain things. So 49(6) is a substantive provision which it is 4 lines only. That's why for convenience I am referring to that. It is not on, may not be there in the notes. What it says, 49 section speaks about the payment of tax, interest, penalty, or other amounts. So 49(6) says the balance in the electronic cash ledger or electronic credit ledger after payment of tax, interest, penalty, fee, or any other amount payable under this act or the rules made thereunder may be refunded in accordance with the provision of section 54. So subject to section 54, whatever the balance available in 49 electronic cash ledger and credit ledger is required to be refunded. So they imposed a conditions that you have to follow the mechanism, a machinery mechanism available under section 54. So it is not an isolated section. I'm repeating, it is not an isolated section which directs that refund is to be granted wherever a balance is available in the credit ledger or cash. It is subject to 54, kindly note it. So on that basis, they have, but the dealer has claimed, I mean the SSC has claimed, that taxable person has claimed that, see, it is substantive provision under 49 subsection 6 directs. You have not brought any kind of a mechanism directly connecting to the issue. Therefore, we should not be stopped to take the benefit of that refund. What I mean to say, closure of proceeding, unavailable, unutilized balance, refund is required to be granted. That was the claim. So closure of a business is not a situation enmarked or enlisted under section 54. Therefore, revenues claim, while rejecting, they made a proposal, observation that no, you are not entitled. Reason being, there is no circumstances is enlisted under 54 wherein on account of closure of business, the refund will be granted on the unutilized portions. On that ground, they have rejected, then he came. His claim is that, as pointed out, that substantive provision directs, you are not bringing any direct illustration-wise, subject-wise restriction or liability. Therefore, I am entitled. That was the claim. Court has analyzed various aspects. Now, some of the few aspects is vital before I coming to the conclusion that judgment was what it was. Few aspects is needed to be noted in order to digest these aspects. If you see section 54, very important phrases are there. We have to see those. When a refund will be granted. 54(1), if you see, any person, kindly note it. See, in the day in, day out, how it is written? Subsection 1, any person claiming refund of any tax and interest, if any paid on such tax or any other amount paid by him, make an application before the expiry of 2 years from the relevant date in such form and manner as may be prescribed. So here the terminology used is any person who is claiming refund, and that refund should be in relation to a tax interest or any amount paid by him under subsection 1. Most important. What do you mean by a tax then? Interest, you know, if delayed payment is made and you are liable to pay not making the payment, interest is reduced. So there are three things: tax, interest, or any other amount paid. Three things. Tax is not defined, but central tax and state tax is defined. Central tax means a tax levied under the CGST Act. State tax means tax levied under the state legislation GST law. So tax can be construed in that manner. In fact, in that context also it is to be seen. So any person who is claiming refund of that tax or interest, not penalty, or any other amount, see the beauty, any other amount who has paid, we have the mechanism under section 49(1). If you see, the mechanism of payment is there. What it says, it should be paid through some channels, that is banking channels, NEFT, RTGS, all these things are noted there. So if that amount is paid, that amount will be credited in the cash ledger. Most important aspects. Why? There is a clear distinctions are there for granting refund also. Whatever input tax credit you are claiming under self-assessment that you are entitled, you are eligible, then that will be credited into the credit ledger. That's what the section says. So it should be recorded payments through all these modes of banking modes are to be in the cash ledger, and balance, that input tax credit which you are entitled, will be recorded in the credit ledger. Now coming to refund again, refund of tax, it speaks about 54(1). It doesn't speak about refund of unutilized input tax credit. So 54(1) talks about any payment which are made as a tax on interest or any other amount, then you can ask within 2 years. Now kindly see the beauty of the proviso. Immediately after 54(1), you will find a place of proviso. How the proviso runs? Provided that a registered person, you will find in subsection 1, a person. That's the difference. Here it says, provided that a registered person claiming refund of any balance in the electronic cash ledger, in accordance with the provision of 49(6), may claim such refund in such form and manner as may be prescribed. In my opinion, proviso is an independent provision itself. It has no bearing or restrictions which are contemplated under other subsections, 49(1). Because 49(1) deals with a situations to a person who has paid tax, interest or anything. 2 years restriction. So my independent opinion in respect of the proviso is that it independently works like a section, this proviso. It speaks about a registered person and balance in the cash ledger to that registration person. If he applies, he is entitled. There, no time limit is provided. But sometimes we presume that no, that original one, subsection 1 provides some 2 years. Therefore, a restriction is there. These things are needed to be understood so that we can digest the judgments. That's why I'm pointing out these aspects. Why this proviso is an independent mechanism, I am not saying. It is saying Supreme Court, not under the GST law. If you go back, Devki Devi versus State of Orissa, and State of Orissa versus Devki Devi, you will find while interpreting the local sales tax law prevailing at the time in the State of Orissa, they said that proviso immediately after a particular section and subsection doesn't mean that it is relating to that section. It has an independent concept which we should understand. Independently, it is to be read out. So a proviso immediately below to a subsection or section doesn't mean that that section governs that proviso. No, answer is no. Therefore, it came for a test in under Bombay Sales Tax Act before Bombay High Court also. In Bombay High Court, in the matter of Commissioner of State Tax, Maharashtra State, Mumbai, at page 3, Lucas India Service Limited, 2012. Lucas, Surte Saab has argued this. Relying upon Devki Devi, they said that for the purpose of limitation prescribed in the assessment mechanism under section 33, a 4A is there. Below 4A, a proviso is there. That proviso doesn't govern that section 33(4). In fact, it applies independently. It should be looked into independently. So keeping in mind these aspects, if you read this proviso under subsection 54(1), it independently works. This is my opinion in view of these two judgments. So provided that, that's why the term person is there in the earlier, 54(1), and in the proviso registered persons. So a registered persons claiming refund of any balance in the electronic cash ledger in accordance with the provision of subsection 6 of 49 may claim such refund in such form and manner as may be prescribed. Here no restriction. No restriction means time bound is not there. So he can make an application. Then coming to subsection 3. Subsection 3 contemplates a situation where unutilized input tax credit are available in the credit ledger. Then the end of any tax period, in an end of any tax period, not in between. In an end of any tax period, you can claim, provided that here it is connecting to subsection 3. that proviso is not an independent mechanism here. It is again connecting that no refund of unutilized input tax credit shall be allowed in cases other than zero rate supply and where the credit has accumulated on account of rate of tax on inputs being higher than the rate of tax on output supplies, except supplies of goods or services both is notified by the government. I mean, where there is a rate differences came by virtue of something, some changes in the law, in the rate notifications. If there is a differences that or wherever the tax amount which you have paid under the zero rated or claiming under the zero rated section 16 of the IGST Act. Under these two conditions only, you can avail the refund under section 54 subsection 3. And that should be unutilized input tax credit. So far as the cash ledger and cash payment is concerned, as I pointed out in 54.1 or proviso to 54.1 governs. Wherever ITC is there, that ITC unutilized portions will be governed by this 54.3, subject to these two conditions, and fourth condition by way of second proviso also given, that duty drawback aspects. There are a lot of changes. We are not on that topic, on the duty drawbacks. So subject to this, a refund of unutilized portions can be granted. Only these are the three circumstances which are enumerated or enlisted in 54.3, which says that wherever unutilized tax component is available in the ITC ledger, credit ledger, which is in relation to zero rated supply, number one. Number two, about this cash, I mean, what it called? Inverted duty structure. On account of that inverted duty structure, any balance is available in the ITC ledger or on the duty drawbacks. These are the three situations where, now once again I am repeating, 49 subsection 6 is substantive provision. What it directs, subject to 54. Now 54 is enlisted. Now in the judgment in our hand before the Sikkim High Court, I mean the Sikkim High Court's decision, there the claim was substantive provision is provided, but no machinery illustrating such a situation is given in the closure of the business. Therefore, he should not be debarred, he should be granted. Now, we have came across various such type of disputes in the VAT arena, as well as under the Bombay Sales Tax arena. We have fought it in various forums, including High Court and Supreme Court. Now, what Honorable Supreme Court says, High Court of Sikkim has granted. Okay. Now, High Court Sikkim has granted. Now, the first and foremost question arises, whether you can take the benefit of the same situation in the state of Maharashtra, number one, we can claim. And number two, whether Supreme Court has taken in earlier laws in similar situations a different view or not. So these are the two situations, I mean, arises. First of all, whether Sikkim bench judgment, Gangtok bench High Court judgment is binding on us. First question. High Court's decision, whether that is binding on us. If you are claiming being a central legislation brought by the legislature, Indian Parliament, throughout the territory of India, because territory is defined throughout the territory of India, it is brought, whether it holds good a decision because it's a central legislation, and can we take the benefit of the precedent and avail the input tax credit, not only in the case of a closure of business, but also other situations wherever unutilized portions is there. Apply 49(6) substantive provision, forget about the machinery provisions and take the benefit. Whether we can take, that is my question. First proposition. Answer is no. Binding precedent is not enumerated under in any Indian constitution. There is no specific provision as such available in the Indian constitution. But by way of stare decisions, I mean judicial pronouncements, a judgment made law is made. Judgment made law is made. That is stare decisions. On the basis of law laid down by the Supreme Courts, these things are developed. If you go into the roots, then one High Court's decision is not binding on other High Courts. It may have a persuasive value. How Supreme Court has analyzed this aspect was recorded in a latest decision by Honorable Madras High Court in our GST law only, while interpreting a GST law. If you see page 4, I have pointed out this judgment of Supreme Court, which is recorded by Honorable Madras High Court in a latest decision. How it reads. The judgment of one High Court is not binding on another High Court. It has only a persuasive value. This was affirmed in Commissioner of Income Tax versus Thane Electricity Supply 1993, where the court held that the doctrine of stare decisions doesn't make a decision of one High Court binding on another. Quoting from Vellama Champaklal Pillai versus Sivantu Pillai, the court noted that there is no provision of law elevating the ratio of the High Court decision in binding precedent for another High Court. The doctrine of stare decisions applies only to coordinate benches of the same High Court. It is equally well settled. Decision of the one High Court is not binding precedent on another High Court. The Supreme Court has reiterated this aspect. So High Court's single decision is binding. I mean, single judge's decision is binding on the territorial jurisdiction of the same High Court or the other benches of single judge. A division bench judgment is binding on both single and division bench of the High Court as well as to the lower judiciary or authorities and the citizens of within that territory. Wherever they have a differences of opinion, the recourse is to refer to the matter to third bench or to a larger bench. This was very clear in the principles laid down by the Supreme Court. But wherever the questions comes in respect of the decision of another High Court, it's not a binding precedent. It has having a great value, persuasive value. We can adapt, you may not adapt. In Kusum Ingots, Supreme Court has very clearly laid down. Supreme Court, Kusum Ingot Alerts versus Union of India in 2004. Supreme Court held that. See the beauty of that judgment. Slightest difference. That's why I'm pointing out this aspect. The court must have the requisite territorial jurisdiction. An order passed on writ petition quashing the constitutionality of a parliamentary act if a central legislation where a constitutionality is challenged and a high court is taking a decision on that constitutionality in that central legislation, then whether interim or final, keeping in view the provisions contained in clause 2 of Article 226 of the Constitution of India, will have effect throughout the territory of India. Kindly see the beauty. In Kusum Ingats, what says? Wherever constitutionality aspect is challenged, then in such circumstances, if a judgment is coming, that judgment is applicable in the case of a parliamentary legislation or central legislation throughout the territory. Not in all other cases. So wherever the constitutionality is challenged, like say under the GST law, whether a tax is leviable to a cooperative society or not, or a club to their members or not, this question came up before Kerala High Court. Constitutional validity was challenged. That is ultra virus to the Constitution. 7AA, which was introduced in the CGST Act, was ultra virus to the Constitution. So that challenge came up before Honorable Kerala High Court. While interpreting, along with the Constitution setup and earlier judgments referring, Kerala High Court strike it down, the 7AA, which was brought into the statute. So the constitutionality was strike it down. So Kusumingat says wherever the constitutionality was challenged, then in such circumstances that judgment has having a precedential value throughout, applicable throughout the territory of India, but not in all other cases. As I pointed out, Supreme Court's judgment, another judgment in Commissioner of Income Tax versus Thane Electricity Supplies, this says that a judgment given either under a writ jurisdiction or appeal jurisdiction or any other jurisdiction is not a binding effect other than the same Supreme Court says constitutional validity. Therefore, the judgment pronounced by the Sikkim Gangtok bench, High Court, is not binding on the Maharashtra state. If you take the same view, authorities, okay, well and good. If they are pointing out a different view on the allowability of the refund, even if without the conditions, if they go into the conditions, then in such circumstances, this judgment is not coming as a binding precedent so far as the authorities in the state of Maharashtra is concerned. Now the second aspect. When a substantive provisions, if independently it says that you are entitled refund, like 49(6), then the question will be different. But 49(6) says it is subject to the machinery mechanism provided under 54. Once it says machinery mechanism provided subject to that, then we have to go to the root of that 54, whether you are falling within the situations under which 54 governs. If you are not falling it, then you are not entitled. This is not, I am not saying, Supreme Court says. How? If you read our judgment in the matter of Mahalakshmi, the great Mahalakshmi, okay, which we all together argued, in fact. In Mahalakshmi's decision, Mahalakshmi means the Mahalakshmi Cotton Market Federation versus State of Maharashtra decision is reported in 51, 51 VST at page 1. Their Honorable Justice Chandrachud at that time I have circulated also 3 pages of this. Because in order to understand, otherwise people will say, Sikkim Gangtok bench has decided, let us claim in any circumstances, in any situation, whatever available. व्यापारी भी आ जाएगा, अरे सुरते साहब आप क्यों नहीं ले रहे आदित्य, बाकी सब तो ले रहे, सामल साहब ले रहे हैं, ये ले रहे, वो ले रहे, दिनेश भाई ले रहे, ऑन द बेसिस ऑफ तुम क्यों नहीं ले रहे, ये क्वेश्चन अराइज. Yes, indirectly, that's why I'm drawing a conclusion first on the basis of not my view, otherwise the Sikkim High Court will slap me. So, not on my view, on the basis of Supreme Court decisions I am pointing out. Okay, so you may not stand, you will fail. So your client will catch your neck. That's why I'm pointing out this. So in order to say no, अभी आप लोग सब मुझे गाली देंगे, अरे सिक्किम हाई कोर्ट के डिसीजन पे रतन सामल ना बोलता है, ऐसा नहीं चलेगा. So I am drawing a conclusion. So for that purpose, I am making all these aspects, highlighting, so that it will be helpful not only this ITC claim mechanism, but wherever it comes to you in your path. So in Mahalakshmi judgment, while pronouncing this, they have made a very categorical statement in para 31. Welcome, Dr. Saab. Congratulations. Praveen Bhai Kapde. Pradeep Bhai Kapde. Dr. Saab. See, in para 31 of the decision, which is reported, which is in hand with you, it says a set-off constitutes a concession granted by the legislature in the absence of, page 21, para 31. In the absence of set-off under section 48(5), the selling dealer would be liable under the charging provision of the MBAT Act 2002 to pay tax on the consideration. There is no independent right to a set-off apart from section 48. The entitlement to a set-off is created by a taxing statute, and the terms on which a set-off is granted by the legislation must be strictly observed. Further, referring to Supreme Court's decision in the matter of Godrej Voice Manufacturing 87 STC, if you see in the next para 33, Honorable Bombay High Court has noted it, the Supreme Court's decision for their decision on this. The judgment of the Supreme Court enunciates the judgment of the Supreme Court in Godrej Voice has given the circumstances. The dealer has no legal right to claim set-off the purchase tax paid and of the input tax credit from the sales tax payable on the sale of goods manufactured by him. What it says? It is not a legal right. Second, the entitlement of set-off flows only out of the rules, Supreme Court says in Godrej Voice. The grant of a set-off is in the nature of a concession. It is open to the legislature while granting the concession to restrict or curtail the extent of the entitlement as a condition attaching to the concession. Further, in another decision, in the next page you will find India Agency versus Additional Commissioner of Commercial Tax, Bangalore. There also, you see para 35, last 5 lines, para 35, last 5 lines. The Supreme Court observed that the conditions on which the concession was granted was mandatory, and a liberal view could not be taken merely on the ground that there was a hardship to the dealer. Here, he is pointing out his hardship. I am closed my business, though since a decade I am running my business. In 2019, I've set up business, and 4 crore 31 lakhs available to me in the input tax credit ledger. So grant me refund. So court has said substantive provision says 49, grant it. Since there is no restriction as such pointed out, specifically pointing out the closure of business in 54, therefore grant it. But in Mahalakshmi's judgment, while pronouncing the decision, laid down in the principles, they followed the decision of the Supreme Court in Godrej voice and in the agency. They said whatever may be the hardship caused, it is not a legal right. Whereas the language used in the Gangtok's judgment, I mean Assam's judgment, wasted right is created, which is contrary to all this. So it is my personal opinion, as I pointed out to two aspects, that it is not a binding in nature in view of the decisions which I pointed out. And second is, Mahalakshmi, you are standing in the state of Maharashtra, Mahalakshmi ke andar hi hai. And already a decision is given saying that input tax credit or set off how you are entitled, and it's not your legal right, you can. So keeping in mind these aspects, you have to examine whenever such sort of, I mean, claims are coming from your dealers to you before making an application. Hope it is very clear so far as this particular decision is concerned in all aspects. Yes, sir. Assisted. Rule 5.
And it is based on, although it is not through a reasoned order, but it is only relied on this judgment of
Yes.
Slovak India.
Slovak India, under the central legislation, Rule 6, they have, I mean, Senvet Rule 6, adopting, I think, that one. So they granted the benefit of ITC, which was not, came up before Supreme Court. It's not a Supreme Court decision, in fact. So they said that in such circumstances, longly it was granted, therefore granted. But you should come with the reasoning what the Supreme Court has says. In Mahalakshmi's judgment, while pronouncing the Bombay High Court decision by Honorable Justice Chandrachud, he has gave the reasoning. So the decision which is given, not binding in the state of Maharashtra, but not a concrete reason is given. Only a relied a tribunal's decision. There is no hardship, no one has claimed and granted. No, now you grant it. Because it causes hardships to the dealer. And it was the view that it was a wasted right. But now court has concluded already. They said that it's not a legal right, it is a concession granted in both Godrej. So conditions enumerated is required to be followed. So the conditions, see, the language is, again, I'm at the cost of repetition, I'm pointing out. 49, subsection 6 is not an isolated 49.6, which blanketly grants that wherever outstanding balance is available in the cash ledger or in the credit ledger, you grant it. It is subject to 54. Once they says, you have to undergo the process of Rule 54, Section 54, which is a machinery mechanism. Again, that machinery mechanism is supported by the procedural aspects under the rules, various rules under which you are entitled refunds. So subject to that only you are entitled. Undoubtedly, if a substantive provision says in one direction and a machinery mechanism, a procedural mechanism goes in another direction, so definitely a substantive provision will prevail. But wherever a substantive provisions makes a nexus, a link to a procedural, a machinery mechanism, you have to undergo through that. Therefore, it is not a vested right, nor a legal right. It is a right came from a statute book, and it is one kind of a concession. You may not available because the contingencies found in 54.3 is not the situation which is claimed therein. Therefore, in my personal opinion, keeping in mind all these with due respect to the judgment, keeping in mind all these aspects of the Supreme Court's decisions, we should not take the benefit as applying to the particular decisions. That's my personal. Now it is up to you.
Essentially under GST, I think will never apply. Because what you said is right. If you go to Senate, they go to Dai, Chikari and all of this, where they say it's the indivisible right. But now under GST, it is again, it is very well bad. So then VAT being just a concession, it's not a right.
Right, already hold. No, in Godrej Boys, I'm taking to once again, you see the second condition, so what it says. It talks about not only setup, but input tax. If you see in Godrej Boys, the situations which they pointed out, the dealer has no legal right to claim setup for the purpose of paid and input tax credit from the sales tax. Second, the entitlement to setup flows only out of the rules. The grant of setup in the nature of a concession, it opens to the legislature while granting the concession to restrict a curtail the extent of entitlement as the conditions attaching to the concession. Already they say, and it's not a legal right. There you will find purchase tax paid and of input credit from the sales tax payable on the sale of goods manufactured by them. So they have well taken care the contingencies. So you cannot sidetrack this one sitting in the state of Maharashtra, as we say. Correct? Clear? Any question? You have a question? Madam, up. Any other questions on this judgment by any viewers herein? Certainly, they have challenged it before the Supreme Court. Otherwise, also, it is not at all applicable, as I pointed. So you have to keep in mind, because it is not like a constitutionality issue was challenged before that High Court. So under Article 226, subsection 2, sub-article 2, that is, it will come in the binding nature. It's not a, I mean, all procedural aspects was under challenge. Machinery mechanism was under challenge. So any other questions on this? Then you can switch over to another judgment. Yes, sir. Joshi sir, boliye. Yeah, please. Yes. Yes. ITC, granting of eligibility of ITC and granting of ITC and eligible to credit in the credit ledger is a different thing than the grant of refund, you mean to say. So unutilized portions remain in the ITC ledger balance. Are you eligible to claim refund or not? That was the question when you are closing the business. So I'm not talking about whether you are eligible to ITC, are you entitled to credit in your credit ledger or not? That question was not there. Even. Yes. Challenged. So that was not challenged. So whatever the credit ledger balance is available at the closure of the business, I am entitled as a refund, you grant it to me. That was the claim. Provides the contingencies. Contingencies.
Now, if we actually look at wherever all this Ali MP and all of these matters, where they said that why you can either control
Control.
the or carve out an exception. But it cannot say something is already not there.
In my first 10 minutes, I have pointed out proviso is a different. Why I have pointed out? Not in this context, in order to make digest understand. A person who is claiming a refund on the tax paid is entitled for which a 2 years limitation is provided, 54(1). If you see a taxable person who is entitled from the cash ledger balance is a refund, there is no restriction as such pointed out about the 2 years. So proviso is to be read again independently. In that context, I have pointed out that. So if you overall consider the situations, we should not accept it unless and until a clear verdict comes from the Supreme Court with analysis and clear principles laid down the principle, means laying down the principles, then only we should accept, otherwise we should. That is my personal view. Up to Aditya now to take. Dealer bolega कि refund loan लेगा कि नहीं लेगा, it is up to Aditya.
I think that also will not trigger that asset. So,
So we should not go. That's a charging mechanism you are talking about, Section 9. No, it won't help you because concession it's a benefit. Benefit is subject to condition, and it is the legislature's wisdom whether to curtail or to grant fully or absolute. So once it is curtailed, we have to go by that curtailing method. Now, ये situation मेरे पास आया भी है, अभी हमारा महाराष्ट्र में भी आया. Connecting to this, वो बोलते हैं कि restriction नहीं है, तो ITC लो ना. Specific restriction किधर है? तो मैं दो situation बताता हूँ. Because next judgment is not that much time taking. Okay. Once you understand this situation ऐसा है, देखो चार्जिंग मैकेनिज्म है, सेक्शन 9 है, फिर सेक्शन 9 गवर्न्स टू द काउंसिल का रेट नोटिफिकेशंस को, या कंपोजिट अदर सप्लाई है तो सेक्शन 8 को है. ऐसी सब एस्पेक्ट्स है. स्कोप ऑफ सप्लाई जो चार्जिंग मैकेनिज्म में है, टैक्स विल बी पेड ऑन द सप्लाई ऑफ गुड्स और सर्विसेज, इतना बोले. नाउ कौन सी सप्लाई ऑफ गुड्स और सप्लाई ऑफ सर्विसेज विल बी ट्रीटेड एज ए सप्लाई ऑफ गुड्स एंड सर्विसेज सब्जेक्ट टू सेक्शन 9 चार्जिंग प्रोविजन और नॉट. फॉर दैट पर्पज उन्होंने 3 लिस्ट दे दी. लिस्ट 1 विदाउट कंसिडरेशन बट सप्लाई है तो है. लिस्ट 2 whether it is you call it is a services or call it is a goods or vice versa, वो schedule 2 में. schedule 3 if you read the top headlines, neither it is a supply of goods nor supply of services. Section 7 recognizes, Section 7 is a substantive provision. Section 7 recognizes that Schedule 3 enlisted are not falling within the parameter of scope of supply. That means neither they are supply of goods nor supply of services. Therefore, सेक्शन 9 आ रहा है नहीं, वो आएगा ही नहीं अंदर. अभी क्वेश्चन सिचुएशन, अभी कीपिंग इन माइंड दिस सिचुएशन. शेड्यूल 3 का लिस्ट में देखेंगे इमूवेबल प्रॉपर्टी, सेल ऑफ लैंड और सेल ऑफ बिल्डिंग. ठीक है. अदर देन वो एंट्री 5, शेड्यूल 2 एंट्री 5 आप लोग तो जानते हैं, 5B. ओ बिकॉज उधर लैंड भी जा रहा है, 1/3 डिडक्शंस भी दे रहा है, वो कंटेक्स्ट में उधर सब कंप्लीटली लिखा है. सपोज ए सिचुएशन कम्स टू यू ड्यूरिंग योर प्रैक्टिस, ए पर्सन मेकिंग ए प्लॉट एंड सेलिंग इट. ठीक है. प्लॉट बना रहा है और सेल कर रहा है, उसका 90% टर्नओवर उसमें, एंड 10% इज ए बिल्डर डेवलपिंग एंड सेलिंग. एक्यूमुलेटेड आईटीसी कॉमन है, सबके लिए, करेक्ट? एक्यूमुलेटेड आईटीसी कॉमन है। क्वेश्चन अभी उठ रहा है, आर यू एंटाइटल्ड द एंटायर accumulated ITC? Are you eligible under section 16? Number one. Number two question arise होता है, because as I pointed out, schedule 3 में that sale of these plots, M-marked plots, are not subjected to levy because of schedule 3, neither supply of goods nor supply of services. Second situation, you are having a business in this Maharashtra state. You are importing, you are exporting, doing local business also. At the same time, your 20% business is out and out. सिंगापुर से लेते हैं और अमेरिका में देते हैं, दुबई से लेते हैं, इंडोनेशिया में देते हैं. Common input tax credit is generated here. तो क्वेश्चन ये आता है, since there is no restriction as pointed out specifically, है, I will point out where there is. So 50, I mean section 16 read with section 17, you are eligible. अगर आप असम हाई कोर्ट को डिसीजंस को नजर में रखेंगे, since there is no restriction specifically pointing out in the section, therefore you are eligible. अगर उसको आप थोड़ा लिंक करेंगे, नहीं करेंगे आप, मुझे मालूम है, अभी थोड़ा रुक जाइए, थोड़ा, फिर बाद में फुल इंटरप्ट करिए, क्योंकि बहुत सारे लोग का पास केस है, मेरे पास भी आया हुआ है इसमें, और ये असम हाईकोर्ट को भी रिलाई कर रहा है, ये सिक्किम हाईकोर्ट को रिलाई करके तो बोल रहा है there is no specific restriction as such pointed out, so claim it fully. क्या जाता है बराबर, आउट एंड आउट सेल, अगेन आई एम पॉइंटिंग आउट, शेड्यूल 3 में जो भी फॉल हो रहा है, दे आर called as neither supply of goods or nor supply of services, nor they are falling within the ambit of section 9 charging to. Keep in mind this. इसको भूलना नहीं, ये अगर भूल गए सब भूल जाएंगे. इसको नजर में रख के सेक्शन 17 में 1 है वेयर आईटीसी ले सकते हैं, 2 को देखो, अगर सेक्शन 17 अगर ब्रैकेट 2 में देखेंगे क्या लिखा है, देखो आप लैंग्वेज, मैं आपके लिए पढ़ रहा हूं. 17 आप मालूम है क्या है, रेस्ट्रिक्शन कुछ पोर्शंस के लिए है ना. क्लेम हमारा होगा कि इसमें तो क्लियरली कैटेगरिकली ऐसा रेस्ट्रिक्शन नहीं है बराबर, तो इसलिए फुल्ली क्लेम करो. रिलाई गैंगटॉक्स जजमेंट, ये दिस for your convenience I am reading subsection 2 of section 17, not 1. 1 to ITC, where the goods or services or both are used, kindly note, by the registered person partly for affecting taxable supplies, including zero rate supplies under this act or under the Integrated Tax and Goods Service Act, and partly for affecting exempted supplies under the said act. इधर अभी वो ये बोल रहे हैं प्रोपोर्शंस निकालो टैक्सेबल सप्लाई की, इंक्लूडिंग जीरो रेटेड एंड एग्जम्प्टेड सप्लाई की, ये बोल रहे हैं. आई एम वेल अवेयर, लेकिन आगे देखो लैंग्वेज, द अमाउंट ऑफ क्रेडिट शैल बी रेस्ट्रिक्टेड टू सो मच ऑफ द इनपुट एज इज एट्रीब्यूटेबल टू द सेड टैक्सेबल सप्लाई इंक्लूडिंग जीरो रेटेड. तो wherever taxable supplies है, towards that ITC is required to be attributed and it is required to be credited. तो जो not at all taxable supplies है, which is falling within the parameter of schedule 3, if you are taking a great risk. So this Sikkim judgment will not even come in your way. सो नहीं है रेस्ट्रिक्शन ऐसा बोल रहे जो वो कार्व आउट हो रहा है। इधर अगर देखेंगे कि the amount of credit shall be restricted to so much of the input tax attributable to the taxable supply, attributable to the taxable supply expressly नहीं है कि शेड्यूल 3 का कटल करो, लेकिन टूवर्ड्स द टैक्सेबल सप्लाई। अगर कल उठ के आपका ये कंटिंजेंसी होगा 98% बिजनेस आपका लैंड डीलिंग है, सेल है, प्लॉट ऑफ, एंड 2% खाली आपकी बिल्डिंग अदर वगैरह सब मांग रहे हैं, आप बना रहे हैं, आर यू एलिजिबल टू एंटायर? सो ये भी एक रिस्क है। नाउ डेज ऑर्डर्स आना चालू हुआ है। सो आप बोलेंगे नो, जहां भी रेस्ट्रिक्शन ऐसा डायरेक्टली इंपोज नहीं हुआ, आई विल रियलाइज दिस असम्स जजमेंट एंड विल क्लेम, सो यू आर टेकिंग अ रिस्क। व्हाट आई मीन, सो ये सिचुएशन वेरियस जगह पे अप्लाई होता है, ध्यान में रखने का बहुत जरूरी है। यस आदित्य सर।
Just taking a point from the speaker, and I have understood that you are fully aware of 73. You are fully aware of the provisions of 42.
42.
The expenses there is. You are aware of like all of that. Still, I think because the other day also we had this,
There only it is stated exempt to supply.
The line argument or form of opinion appears to be that since this outcome of transaction is not a supply at all, then any ITC attributable to this, because from what you just said, 17 subsection 2 talks about that ITC attributable to taxable supply. What action? Can I take the same argument and reverse it to say that yes, agree with that whatever is appearing in schedule is not a supply at all.
Correct.
Section 9 does not apply. Therefore, where am the situation where a part of my supply and the rest of my turnover is taxable supply, 17.2 does not apply to me at all. Because 17.2 only comes into picture when a person is engaged in taxable supply and exempt supply. That 2% of my turnover is neither taxable supply nor exempt supply. Because it is not a supply at all.
Correct.
And therefore, I will not go into section 72 at all.
At all.
61 allows credit for 71 is not applicable. 72 also I will not apply because it doesn't get attracted at all. Because it only comes to a picture where there is a turnover is not a taxable.
I understood your question.
Can I take that?
Answer is no. Reason. Section 16 is not to be read isolatedly. It's a machinery mechanism. It should read with the substantive aspects. Where this act applies, it starts from that, subsection 1. This act applies throughout the state of Maharashtra or throughout the territory of India. Taxable territory is also defined. Non-taxable territory is also defined. So if you consider the entire aspect read with the charging mechanism section 9, then the conclusion will be ITC is a concession granted when every stage tax burden is there. In order to avoid that one, you are entitled, subject to certain conditions, the benefit of the inputs. In that context, if you see at broader length, with all these substantive mechanisms and charging mechanisms, then it should be read as this will be applied only where there a taxable supply is there, ITC is generated. This is my personal view. Yes.
Considering that Schedule 3 transactions are transactions on which GST is not levied.
Not levied. Not falling under section 9.
And which is the case in many cases. Now, I will take the second argument of 17 subsection 3. 17 subsection 2 says that wherever a person, registered person is engaged in supplying goods or services which are effecting partly taxable supplies and partly exempt supplies, then in that case he has to proportionately reverse it.
Where not.
Category states that that the value of exempt supply under subsection 2. So they are specifically defining what the exempt supply under subsection 2 is going to be.
Yes, exempt supply means.
Shall be such as may be prescribed. Some prescribed we understand by a general meaning of rules. But over here there is no rule that is prescribing what is exempt supply. Rule 42 provides for mechanism of reversal. So let us for the time being take it that what they have defined what exempt supply is, and that is where they are referring that as may be prescribed.
So you mean to say schedule 3 is also an exempted supply?
And subsection shall be such as may be prescribed, and it shall apply on which the tax and the commercial is applicable. That is not none of our concern right now. Transaction security, sale of land, and subject to paragraph 5B of schedule 2. Then
Section 8, entry 8.
yes. Now there comes an explanation of for the purposes of this subsection, that is subsection 3 of section 17. The expression value of exempt supply shall not include the value of activities or transactions specified in schedule 3.
Schedule 3 may specified 2 items.
Except schedule 2. Means that 2 items will get included in the value of exempt supply for the purpose of 17.
Yes.
For the purpose of reversal.
There is a logic behind it. It is connecting to the construction activity qua that particular land. So connecting to that aspect only, they said that first entry, and connecting to warehousing, that entry 8, this speaks about. Rest are, they are saying no, they are not exempted supplies. 2. Yes. No. Yes, no, in that, not in that context which you are construing. In the context which under schedule 3, there are certain items which are even a portion is subject matter of levy is there. So they carved out that one and picked and choose there to put it in the exempted supply. Rest of them are not exempted supply because reason behind it. There are canton of judgments on it. Wonderful. There are certain situations where it is into a taxable supply. It will come under the taxable supply, and some contingency they will not come at. Yes. So, what I will point out, canton of decisions is there. Taxable. Yes. Yes, in that.
That means they are specifically including
2.
which means they are admitting that the other
Exempted. Other are not supplies it. Because the head note itself says neither supply of goods nor supply of services. Correct. So therefore, the others are neither supply of goods nor supply of services. So in the context of that output supply, if you are any ITC is accumulated, that's not it. No, come in. Eki. Dinesh bhai. Exempted supply means what? Yeah, exempted rate means what? A tax is leviable. I am not saying, Supreme Court saying in Tata's case. A exempted means which is leviable, but by virtue of certain contingencies or notifications or situations enumerated, they are deemed to be treated as a not taxable, exit to tax. They are falling within the ambit or parameter of supply, but by virtue of force that has been carved out from the scope of that and taken out. So this is called exempt. Levy, nil rate, 0 rate, all these are the different aspects under this. So all these situations or circumstances will come when it is falling within the parameter of section 9, charging taxable supply. When tax is leviable on the supply of goods or services, all these are connecting to that. अभी दिनेश भाई तो वेरी करेंगे ही करेंगे. अभी ये सिचुएशन आएगा हमारे पास, आ रहा है. So you have to keep in mind this aspect. Blindly असम का जजमेंट को नजर में रख के ये हमको लेना नहीं है, ये मेरा कहना है. अभी दिनेश भाई पूछिए आप क्या कहते हैं. Yes. Not.
Let us read the rule. Sorry, section 49(6). I'll read.
Yes, please.
The balance in the electronic cash ledger or electronic credit ledger after payment of tax, interest, penalty, fee, or any other amount payable in this under this act or the rules made thereunder may be refunded. Now this is important. In accordance with the provisions of section 50. It doesn't say that.
Subject to the condition of 54. In accordance means a machinery mechanism is carved out.
This is substantive provision. 54 is
Correct. Machinery, not procedural. I'm not saying procedural. Machinery provision and procedural aspect is different.
Provision is provided for refund on certain conditions.
So that now machinery provisions will be converted into substantive once it relates to that machinery mechanism. See 49, if isolated, if they would have been said, what the Sikkim court says would have been correct. But they said that subject to 54. Once, I mean, in accordance with the 54. So 54, if in accordance with 54 language, you have to go undergo. Bypass surgery होना चाहिए 54 को.
Then it cannot be much. That is what the
Court is said, yes. There is no express restriction is provided in 54. Therefore, we are ending. No, not in accordance with 54. Not only you have to read with this as the line in which you are reading, we have to keep in mind the Supreme Court's decision in allowing the claim. You have to keep in mind these three. That's why मैंने ये इतना अंदर लिया है. Yes. Whatever it may be, the India agency's judgment, what says, whatever may be the hardship is caused to the dealer, you should not see. It is the legislature wisdom to grant benefit or not. So we have to see that part. Even if it is caused a hardship, closer हो गया business, खाने को वांदा भी हो गया, then also helpless. ये कह रहा है India agency. Yes, madam. Any question?
Even ITC is to be restricted as per 17 to 73. It should be read with expression 3 to what.
हाँ, आदित्य ने बोला.
And with the balance available in the electronic credit ledger of previous years can be used to make payment of IGST. While
that is subject to different aspect है. How to adjust that one, that is different rule, different provision is there. How it is to be adjusted. अगर आपका IGST है, first you adjust against IGST, then balance you come to the CGST. Like that, the mechanism is to be followed. That is a different part. Okay. Now we can jump to the next judgment. Next judgment is interesting judgment. Again. अरे क्या खत्म नहीं करेंगे लग रहा है दिनेश में. बाद में बात करेंगे ना, हम उधर बार में बैठ गए, फीस भी लेंगे क्लाइंट से, दोनों बांटेंगे, है कि नहीं? फिर वो बात आ जाता है ना. दिनेश भाई खाली 5 लाख लेंगे तो रतन सर को क्या मिलेगा फिर? Okay, now Unicode Autocode India Private Limited versus Union of India. Interesting judgment. See, as I pointing out, always the substantive provisions are there and machinery mechanism is there and procedural aspects are there in the taxation stage. So here, a company situated in the state of Maharashtra is a transferor company, merged or amalgamated with another company in Goa. A company registered under Maharashtra state under the GST regime, GST law, and B company is in Goa. accumulated ITC after this merger acquisitions, whatever it may be, took place or takeover took place, the questions came up before the authority. Am I eligible to transfer from Maharashtra company to the newly amalgamated company in the Goa? Whatever. Reverse, no? Different. Goa to, I'm sorry. Goa to Maharashtra. Goa to Maharashtra. I'm very sorry. Goa to Maharashtra. So now the questions comes registration aspect, because wherever such situation arises, it provides a mechanism. So you will find in section 18, no, I think. Section 18.3 contemplates the situation where a amalgamated merger amalgamations, and when it took place the takeover situation, then in such circumstances a transfer is permissible. But the term used is registered, where I'm reading for your convenience, where there is a change in the constitution of a registered person. See, on account of sale, merger, demerger, amalgamation, lease, or transfer of the business with the specific provisions for a transfer of liability, the said registered person shall be allowed to transfer the ITC, which remains in unutilized in the electronic credit to such sold, merged, or demerged, or amalgamated, leased, or transferred business in such manner as may be prescribed. So this is the central legislation. Okay, applies throughout the territory of India. Keep in mind, please, because it defines taxable territory, applicability of this act. So it applies to throughout the territory of India. Taking of a registration is provided in the machinery, a procedural mechanism. Substance of this says ITC can be transferred provided that a registered person. So Goa High Court has interpreted that it is permissible, being a central legislation. You are not transferring the amount of that particular state, means SGST. It is transferred either IGST or CGST. वो breakup दिया है. एक 1,36,000 का खाली state का था, balance जो है IGST और as the case में भी CGST था. So they said that it is a central legislation. Once you are registered in one state, for all purposes, you are a registered person. So keeping in mind this aspect, they said that being a central legislation, in order to avoid different litigations and all things, a facility is provided. Wherever you are coming up a business, you take registrations there. That doesn't curtails. So in that context, they said that it is transferable. The language says it is a registered persons. Since you are bringing some procedural aspects that wherever your situation of business is there, even in one state, multiple goldams are there, you take a separate, whatever it may be called. These are the procedural aspects. This is not new to us. This is not new to the GST law. If you go way back to our old law, under the Bombay Sales Tax Act also such a situation came up. Not merger amalgamation I am talking about the registrations. In Niranjan Mill, you won't get that one. Subsequently, मैंने रास्ता में अभी आते आते मेरे को याद आया, अरे ऐसी situations तो we came across also earlier. I have also argued so many matters before tribunal. तो याद करके ध्यान में आया तो Niranjan Mills ध्यान में आया. The judgment is Niranjan Mills Limited versus State of Maharashtra. Bombay High Court's decision reported in 99 sales tax cases 587. 99 STC 587 reported. There the same situation arises once within the state, because the Bombay sales tax applies throughout the territory of the state. There, situations were there under the procedure mechanism. If you are having an exempted unit, deferment unit, or you are having some other aspects of establishment in another town or another city in the same state, you have to take numbers. If your jurisdiction changes, additional commissioner's jurisdiction changes, then in such circumstances also you have to take number. Such situations were there. गुटे साहब को ये सब बहुत मालूम है. ये सिचुएशन में हर एक जगह पे नंबर लेना है आपको. तो नंबर everywhere you have to take. So this gentleman has not taken number, only one number is there. उसका curtail किए, बोले in that particular town where the jurisdiction is changed, you are not holding number as per the procedure laid down. Therefore, you are not a registered dealer and you are not entitled to take the benefit in that Aurangabad division, Pune division or other division. Every division you have to take numbers. That's what says the procedural part. Then court has interpreted these aspects. They said this act applies throughout the state of Maharashtra. Once you are a registered dealer, for all purposes you are a registered dealer, maybe because of certain difficulties and situations, formalities, or for calculation mode, or maybe for a different purpose. जैसे कि CQB calculation करना है, तो उधर का ऑफिसर को convenient होगा विजिट करके CQB calculation, cumulative quantum of benefit, या deferment का benefit, या exemption का benefit, और various aspects ऐसा है. So looking into that, procedures are there. That doesn't mean that he's an unregistered dealer. So how the language is used? See, the liability to pay tax under the Bombay Sales Tax Act 1959 is determined with reference to the aggregate turnover of sales and purchase of the dealer in the state. It doesn't depend upon registration. Moreover, once a dealer is registered under Section 22, he becomes a registered dealer for all purposes of the Act. Registration is of the dealer, not of his place of business. He cannot be treated as a registered dealer only in respect of a particular place of business and as an unregistered dealer in respect of some other place. The requirement of Rule 7(3) of the Bombay Sales Tax Rule 1959 of application for separate registration in respect of each place of business is a directory. Non-compliance of this requirement renders the dealer liable to penal action, but that cannot have an effect of treating him as an unregistered dealer in respect of any place of business in the state. A dealer who is registered under Section 22 of the Act cannot be treated as an unregistered dealer in respect of any place of business situated in the state. If you apply this principle, then what it says? The CGST Act applies throughout the territory of India for convenience purpose, for smooth assessment, adjudication, self-assessment, or whatever it may be. Administrative purposes, you are granting that registration in a different. That will not come in your way. So, though Niranjan Mill is not relied by them, I came across this, I am pointing out. So, keeping in it this mind, court has directed wherever the central legislation applies, he is a registered person for all purposes. So, under the Goods and Service Taxes Act also, CGST and IGST applies throughout the territory of India once he holds a number. Moreover, penal, you may invite penal mechanism, penal provision, because you are not following that procedural directions or administrative directions. But it doesn't curb your substantive right that you are not a registered dealer. So therefore, it is a valid and good judgment. And Niranjan Mills also says that under the Bombay Sales Tax regime. So if you see in this context, it's a very good judgment and also applies to our state because it is the judgment of our own Bombay High Court. Wrong or right, it will be directly applicable to you. Nothing under the precedent's values. Hope both the judgments का ये किया. अभी ये in the second judgment any query आप बताइए please. Any? So thank you very much. Those who are on the online, yes. Yes. So that will apply in that context. It will apply wherever in that particular place. If it is not situated, it's see. Ultimately, नहीं इसमें नहीं हाँ मैंडेटरी नहीं इनके क्वेश्चन अलग है बट इट अप्लाइज टू देखो रेवेन्यू क्या है जीएसटी ये गोज टू द स्टेट रेवेन्यू कंसोलिडेटेड फंड है स्टेट रेवेन्यू को जा रहा है उधर सिचुएशन कैसे अराइज हुआ एक स्टेट से दूसरी स्टेट को एक स्टेट बेनिफिट ले लिया और उसकी कंसोलिडेटेड फंड में वो जमा कर दिया अभी दूसरी स्टेट को वो ट्रांसफर होगा क्या किधर से होगा वो तो लॉस है उसके लिए whereas IGST and CGST अगर बात करेंगे it is both proportionately कैसे sharing है वो already determined under the constitution mechanism after GST amendment. So it doesn't hold ये सर का भी क्वेश्चंस जो भी है आपकी साहब इसमें आपका substantive provision will not come in your way. Maybe a penal mechanism or procedural aspect will hurdle you. But it goes to the state only, that amount. You got my point? Procedural and other aspects may, you will come form and formalities, jo bhi hai, and penal action may. As I said, Bombay High Court has said. Convenience purpose.
The only thing is that whether that CGST, that is what whether that CGST of other charges of Gujarat, CGST components based on this judgment.
No, this judgment will not apply there, which you are pointing out. Wherever an immovable property like a hotel is created in another state, then it is consumption basis tax. GST is a consumption basis tax. So consumption basis, you are entitled the benefit if it is carved out. If restriction is put out, you are bound to follow that restrictions. नहीं वो registered and non-registered concept में कहाँ? Yes.
Input tax credit covers CGST also. And CGST which is applied to the all of it. Why the tax credit should not be eligible for?
But legislature with their wisdom they brought such situations. Section restricts, no? Section 17 में है ना ये situations hotel immovable property.
What will happen is I have a registration today. I give you our GSTPAM example. So we go for our that is in
Rajasthan.
Okay. So now he's going to because there is an
Immovable property there. And the benefit will be accrued to that state. Are you entitled to this?
Yes.
Answer is no, because if they carved by way of some provision. All purposes throughout it, yes. CGST survives, so you can take shelter of this one. Unless restriction is there specific in substantive provision. Pradeep Saab, Dr. Saab, what you are saying?
On the portal. Now this judgment exactly comes from the portal.
Yes.
It says that transfer
Portal only. Yes, this.
And that is what the court has told to rectify this error of the court within 6
Yes.
weeks from the date of the judgment. So and therefore GST to rectify.
So a representation can be made and a portal to the extent of this portal. I agree. Hmm. Hmm. Not allowed. Amendment. Here, a separate provision was there under section 83. Brought it. Query.
In the larger
Prospect.
tomorrow, the state government, or is it possible that the state government SGST law amend the wording of 18.3 to state that only in case of
18.3 they cannot amend is because in the constitutional setup, wherever it affects two different states, one state isolatedly cannot make such mechanism. That is the bar is there, constitution bar is there. It is the central legislation only can do by the parliamentary act, but not the state cannot touch wherever interstate is involved. They cannot, no. So they cannot make law also. You can make a law with respect to your own territory. Wherever different states are involved, then is isolatedly if a state is making, they cannot make because of the constitution bar. See, there are 3 lists are there: union list, state list, concurrent list. You must be aware. So union list is in respect of this, state list is this. So subset is enumerated.
The wording is the same as CGST. There is a change in constitution of a registered person on account of same budget versus words. With the specific provision of transfer of liability, the same registered person shall be allowed to transfer the estimate which remains unutilized in his electronic bid ledger to such stored merged demerged workflow in such manner as may be prescribed. So I am only talking about a hypothetical situation.
That is in respect to the Goa merger if take place, two companies, those who are situated in between, there only. No, they cannot amend it. Same state. They can say because same state, it is applies to the same state only. Otherwise also, no, they cannot. Wherever other states are involved, they cannot make such. It clearly spells that it will apply to that throughout the territory of Goa. So a merger or amalgamation took place between two companies, those who are situated in the Goa, that will apply. They cannot touch wherever the other states are involved.
So this
cannot make because of the constitution restrictions.
There is no restriction that
Yes. Substantive provisions.
So the wording being paraphrased 100% same. So
No. It is a central legislation. They have gone to that aspect. Central legislation, if speaks in one voice, that has always will upper hand. And central legislation, once in the substantive provision, they say that it is transferable, means transferable, irrespective of your procedure state mechanism. Keeping in that mind only this judgment. Registration, it speaks about the registration. Whole of it.
And section 25 SGST applies only to the state activity. That is where the only police requires there can be a difficulty claiming SGST from.
No, otherwise also substantially it creates by virtue of 18.3, then it applies throughout the India, wherever maybe the states are situated, and central legislation always will apply. Keeping in mind this is sports. स्टेट का खाली जो है जितना 163 छोड़ दिया, अदरवाइज आप देते थे गलत होता था। नहीं, स्मॉल बात नहीं है, अदरवाइज ऑल्सो वो नहीं कर सकते बिकॉज यू हैव कंज्यूम्ड इन द स्टेट, सो द बेनिफिटेड स्टेट इज दैट स्टेट इटसेल्फ। ओके, होप बिकॉज वो नहीं, वो प्रोसीजरल मैकेनिज्म प्लेटफॉर्म में वो ट्रांसफर नहीं होगा ना, अदरवाइज आप कितना भी क्लेम करो। हमारा मैनुअल रिकॉर्ड नहीं गया ना गुट्टे साहब, मैनुअल में पहले क्या है हम कुछ भी करते थे, वो नहीं चलेगा ना इधर, बिकॉज यू हैव टू गो थ्रू द प्रोसेस ऑफ दिस प्लेटफॉर्म्स। सो कीपिंग इन माइंड ओनली वो काउंसिल को डायरेक्शन। होप हाँ, यस यस।
There is no restriction mentioned in claim of refund of block credit. Therefore, if the business is closed and ITC credit was awarded towards block credit, can a refund still be awarded? Section nowhere specifies refund of eligible credit
No.
only.
No, as अभी तो मैंने क्लियरली सब एक्सप्लेन कर दिया है। यस वो घुमा फिरा के पूछ रहे। आंसर इज यू कैन होप और नो अदर क्वेश्चंस सेजल मैडम या पार्थ? हमारे अर्जुन, यस, थैंक यू वेरी मच giving me this opportunity on the first day of this study circle, Parth. Thank you to everyone.
Before the actual vote thanks, I really like to thank you. These are topics which we needed like council like you to come and regulate it better. So thank you. Just I like to add that here you have a very useful perspective to this judgment. Don't apply the judgment blindly. The judgment may not apply to other territories of India other than the 16th region. So I think and again he started with the basics of what what arguments to come against what his final conclusion was for the judgment. I think it was really a remarkable session. Thank you.
Yeah. Good afternoon.
आपको बोलिए क्या है ये तो क्या देखो आगे हो गया
Yeah, good afternoon, everyone.
Before you make a small announcement. So recently, the Sales Tax Tribunal Bar Association had conducted a seminar on 1st and 2nd of August, and we had from that seminar there are some remaining kits available for sale at 11,000. 1,100. Sorry, 1,100. So if anybody is interested, it is kept for sale at the counter over here. Please, you can look at the booklet and then you can buy it. It's very good booklet on various topics, including development of buildings and pharma sector and GST tribunal regulations. Please go through it, and if required, please buy it. Thank you. And the bag is also of very good quality. Very good quality.
Okay, good afternoon, everyone. Under the erstwhile VAT regime, registered dealers had the option to claim a refund of accumulated input tax credit. However, with the advent of GST, refunds became restricted to specific scenarios, such as for zero-rated supplies or supplies involving an inverted duty structure on goods, etc. It was a prevalent view that since the GST law does not explicitly provide for refunds of accumulated credit outside the specific scenarios, such refunds are not permissible. The judgment presents an opportunity for taxpayers with unutilized input tax credit, particularly those whose businesses have ceased operation, to file refund claims. So it is my distinct privilege to propose a hearty vote of thanks on behalf of GSTPAM to Advocate Ratan Samal sir for his insightful presentation on the complexities of claiming refund of ITC, on the closure of unit with the clear explanation, including the interplay of section 49(6), 54 and 54(3), and the second case law regarding amalgamation of two companies registered in different states. We sincerely appreciate your time and expertise in shedding light on this important topic. You have shed light on a crucial aspect of GST law, providing much needed clarity for business facing similar situations. Your expertise has the audience understand the potential avenue and challenges ahead. Thank you again, Ratan sir, for a truly informative and engaging session. I also thank all seniors, past presidents, and members for your presence, those who have attended here and as well as online. Thank you. Can we rise for the national anthem? Punjab, Gujarat, Vindhya, Himachal, Uchan, Jalandhar, Tava Shubha Name, Tava Jai, Jana Jana, Thank you.